My name is John Walubengo. I'm a lecturer at Multimedia University of Kenya. I want to thank CIO for making it possible for me to share my views on data protection, a law that was enacted late last year, but now quite active with the data commissioner being in office. I think she took the oath of office last week. So I believe this session is quite timely. I will jump straight into the slides where I talk about rethinking our data strategies in light of this new act. We'll go through a couple of definitions just so that we're on the same page in terms of terminologies. Then we'll focus on the data subject rights as well as the data controller rights. We'll see who those are and the implications for the enterprise. In terms of definitions, privacy is the right to be left alone. So basically that means when you get into your home, you don't want people to be prying into your activities that may be taking place in your house, whether they include having your dinner or watching movies, or basically just getting connected to your family. So privacy in the home setting is well understood, but with new technologies, what has happened is that the capabilities of these technologies, whether they are cameras or just simple browsing on the internet, leaves a lot of data footprint that third parties can review and build a profile around who you are, what you do, how you do it. So privacy is now sort of at a risk because of developments in technologies, digital technologies especially. For the techies, there's always the challenge. What's the difference between data privacy and data security? This diagram perhaps will help in that security is what the IT guys have always done: encryption, protecting our perimeters, providing login scripts, and they need to continue doing that. But they need to now think of privacy. Whatever they're doing for the enterprise, they need now to do for the users, for your customers, from the personal data's point of view. So the data you collect about your customers that is of personal nature requires the same level of security as what you have for your enterprise. But more importantly, there's something they call data subject access rights, DSAR, where enterprises are now expected to provide facilities to their customers so that they exercise their privacy rights, and we'll see what those rights entail. In terms of definitions, personal information vis-a-vis sensitive personal information. So in a nutshell, personal information is just any data item that can be triangulated to zero in on a unique user or a unique customer. So that will include email addresses, my ID number, my device number. You're aware that your phone number, for example, has a unique number that is not repeated across the globe. So if somebody can locate that unique ID and map it to your name, then they pretty much have an idea of where you were last weekend, where you went, where you stopped, where you rested, etc. So this is private information that the new act aims to protect from abuse. Now, sensitive personal information includes information that could cause, significant harm to the user if it falls in the wrong hands. So it includes our biometrics, our genetic details, in some countries, your racial and ethnic background, all this sensitive information, medical data can be used against you, you know. And a quick example is if for example I'm applying for a job. In the early days of HIV, it was obvious that employers were discriminating against people who are HIV positive. So that data should be protected. You should not, like, if you're aware I'm HIV positive and I perhaps trusted you with that information, you as the custodian of that information cannot share it with the third parties without my consent. Okay, so other significant personal information are listed: sexual preferences, political opinion. So this, from an enterprise point of view, if your enterprise is in the course of its business has to collect this information, then it must sort of attribute extra care to that sort of personal data. A data subject is a customer. A data subject is a patient, is your client, is, you know, your passenger. It depends on which industry you are in, but at the end of the day, a data subject is your customer. In the university, our data subjects will be the students. And each of us in our own context is supposed to treat personal data of the data subject with extra caution. A data controller is the enterprise, the people who determine the purpose of collecting personal information from the data subject. Okay, so the Act puts extra obligations to you as the data controller, particularly in terms of ensuring the data subject enjoys their data rights. And we shall see what those data rights entail. Now, as a data controller, you could also subcontract. So the usual example I give is Safaricom is a data controller. They determine the purpose of collecting our information at the point of subscribing to the service. But Safaricom has, I think now, close to 200,000 M-Pesa kiosks. So the people at M-Pesa are collecting our information, but they're doing so on behalf of Safaricom. So the relationship between Safaricom and the kiosk vendors are data processor relationship. The Act anticipates that both of them are, you know, liable in the event of data breaches. The data commissioner will blame both, but she will be in a position to adduce who has the higher blame, depending on the case-by-case basis. So the Act has various areas, but I'll just pick, I think I want to pick two key ones. You've got a lot of principles, which are global principles of good data protection, but those principles are exercised by data subject rights. And I want to jump to those rights in a nutshell. This particular slide summarizes the rights of your customers. And as an enterprise, when you're trying to fulfill those rights, you're actually observing the principles. So the first right is, as your customer, I have a right to transparency. So you as the enterprise must tell me, as you collect my information, what are you going to do with it? Who are you going to share it with? In case of breaches, I have a right to know that a breach has occurred. So the Act, you know, forces you as a data controller to alert me. As a consumer also, I have a right to access. If you collected information about me, I have a right to access that information. And again, back to Safaricom, they collect information about our M-Pesa transactions. You'll notice that over the last 3 or so years, we can access our M-Pesa transactions going back, I believe, 6 months. So I have access. Previously, 10 years ago, I mean, we didn't even know that we could access that information, our historical transactions. And I give Safaricom as an example, but you should think of your own context. Which information are you collecting about your customers that you're not sharing with them because you'll be in violation of the Act? We have a right to correction. And you realize that as your customer, I cannot demand correction unless you've provided access. So all these rights are sort of interrelated. I'm not in a position to know that the data you hold about me is in error unless you provide the access. I have a right to erasure. If I'm leaving your company, I have a right to say, hey, get rid of my information. And you have a duty to do that task. I have a right to object to certain types of processing. So I may say I'm not leaving your company, but at the same time, I should negotiate how you use my data. I have a right to do that. I have a right to portability. I should be able to download my M-Pesa transactions and move with them to your competitor, Airtel and others, Telecom Kenya, so that they see my credit history. It's to benefit me, not just you alone as the original data controller. So I'll skip this because you need to just realize that the obligations, the right demands of you as the enterprise are the ones that facilitate my enjoyment of these rights. I want to go towards the end and say that being compliant is important because it's good for your business. In the process of being compliant, looking at your data processes, your data assets, mapping them and seeing where they are located, it improves your understanding of your enterprise. There's a requirement that you do a data protection impact assessment, which is the tail end of data mapping. What are the risk factors that your enterprise is facing? And this time from the perspective of your data subject. Many years, I mean, traditionally we do risk management from the perspective of the enterprise. We want to protect enterprise intellectual property, for example, but now you got to do the same in terms of protecting the customer privacy rights. If you don't do that, there's a cost to it. If you're in violation of this act, there are certain penalties that range from 3 million to 5 million. Imprisonment, for example, if your employee is in violation, they are individually held responsible, but you as the enterprise also have a fine to pay. So non-compliance is costly. It's not an option. So we need to start thinking of how can we then be compliant. There's always the buzzwords with this area. You need to be you need to practice data privacy by design. So all your modules, all your processes, all your projects that you're bringing on board, you have to ask the question, are they sensitive to the Data Privacy Act? Some of you may need to have an in-house data protection officer as a new role. Some of you may not, you could outsource that. What matters from a data commissioner's point of view is that that role must be present, somebody who is actively ensuring that the data privacy program is actually on the dashboard of high priority. Most of you are multinationals or you have branches in the region, so there's a clause to watch out for. How are you sharing your data, the Kenyan citizen data to your branch in Uganda, Tanzania, or Rwanda? Is that happening, and why should it happen? And when it's happening, are you protecting the citizens' data in Rwanda the same way you're protecting it in Kenya? So these are the questions that should be running through your mind. Then there's a rule that in case of a breach, you can no longer hide. You have to inform the data controller within 72 hours. Failure to which you are in violation. Okay. So we need to do capacity building. I would recommend that the first duty is, or point of action is just to have an awareness program, do some capacity building across the board, get everybody up to speed on the contents of the act, and basically start a privacy culture in your organization. Because if you don't do that, the data commissioner is in town and they probably be coming after you sooner than you think. So I think I will end there. In case of any questions, please feel free to email me either on my Gmail or on my other mail at roma.co.ke. Thank you.